switching out students, so some of you may have heard me speak a little bit before. At this point, I ordinarily would call the next case, but because this is a special occasion of having arguments here at the high school, we're going to take a moment to introduce ourselves in the process that we're here. As any of you who have taken a civics or social studies class know, we have three branches of government, and the judicial branch is one of those three. As Chief Justice of the Supreme Judicial Court, I am actually head of the third branch of government, and probably most of you have never heard of me, unlike the governor or our legislature. So we love coming out to the schools, as we are doing here, so that you can see what we do. Now, as the Supreme Judicial Court, we don't hear trials ordinarily. These are appeals, meaning that a lower court, a trial court, has already ruled one way or another, whether through trial or otherwise, on what would happen in this case. So in this case, there was a trial, and they are appealing to us, saying there was an error in that trial. And that's the issue that we will determine here today. So we're going to go off into the arguments. Before I do that, I thought I would take a moment and have the court introduce itself to you. As I say, I am Chief Justice Stanfield. My chambers are in Augusta. Unlike a lot of states, we actually keep our chambers in different parts of the state, and in fact hear cases in different courthouses in the state as well. So we are also very tradition-laden in our court, and we sit and come in a specified order of seniority, and by that I mean length of time on the court. Now, because I'm Chief Justice, I'm always considered most senior, although I think I obviously am not, and we mean by length of time on the court, though. But I have actually been a judge for 18 years because I was a trial judge before I was on this court. I'm going to ask my colleagues now to introduce themselves in an order of seniority, or reverse order, so I'm turning to the most junior justice.
That would be me. Good morning. I'm Wayne Douglas. I have been a judge for a little over 20 years, most of that time on the trial courts. I've been a member of this court for about a year and a half, and my chambers are in Portland, and I thank you for the opportunity to be here. It's certainly our pleasure.
Morning. My name's Rick Lawrence, and I have been on the court for, the judicial branch for 24 years, and 22 years of that was in the district courts of Maine, and 2 years here on the Supreme Judicial Court. Very much appreciate the opportunity to be here with you this morning, and last point, my chambers are here in Portland.
I'm Catherine Connors. I've been on the court since February 2020. I'm from York County. My chambers are in Portland.
Morning, everyone. My name is Andrew Horton. I have been a judge since 1999. I came onto this court in February of 2020, and my office chambers are also in Portland.
Good morning. My name is Andrew Mead. I've been a judge for 34 years, the last 18 of which were with this court. My chambers are based in Bangor. As noted earlier, we have Old Fourth in Portland, Augusta, and Bangor, and it's a pleasure to be with you here today.
The first case we do have this morning is State of Maine versus Christopher Ray. This is Cumberland 2443. It appears, and it's actually an appeal from the Violations Bureau. It appears counsel are present. I'm assuming ready to proceed. If you could introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning, Your Honors. Lauri, Boxer-Macomber, and I'm here on behalf of Mr. Christopher Ray.
Thank you. And for the state?
Good morning, Your Honors. Student Attorney Ian Semon here on behalf of the appellee, State of Maine.
Thank you. Ms. Boxer-Macomber, if you're ready to proceed, we'd be happy to hear your argument.
Good morning, Your Honors, and Deering High School community. May it please the court. On July 7th, 2023, Mr. Ray, an experienced 60-year-old bicyclist, was riding his bicycle in Cumberland through a residential zone and school zone where there were a number of marked crosswalks and other surface warnings telling traffic to ride slowly. And there are also a number of traffic control device signs, some of those bright yellow signs that have warnings of pedestrians in the area that were present in that location. Mr. Ray was riding 17 miles an hour through the school and residential zone with these marked crosswalks and traffic signs and was lawfully riding. All of a sudden, an unmarked Ford Explorer pulled up right alongside him in what he considered to be a very aggressive manner and shouted at him to ride single file. There is no law in Maine that says ride single file. In 2021, someone proposed it and the legislature did not enact the bill. Mr. Ray did something that was quite unfortunate. I think we all agree it was not the best response. He was scared. He swore at the person in the unmarked Ford Explorer. Then, what was even more unfortunate is that the driver of the Ford Explorer, in response to free speech, put on the blue lights of the Ford Explorer. Turns out the person was a cop or a law enforcement officer, and pulled Mr. Ray over and cited him. Mr. Ray had a traffic proceeding where he was charged with a violation of the section 2063(2) of the Motor Vehicle and Traffic Code, and he lost. And that decision was legally and factually incorrect for a number of reasons, which I've elaborated on. Most of those reasons don't focus, or nearly all of them, don't focus on the egregious behavior of the officer, but they focus on the statute at issue. This is really a statutory interpretation case, and the district court, unfortunately, got the law wrong. The district court did not look at the portion of the statute that requires that the statute only apply when bicyclists are not riding the normal speed of traffic. So it read the statute without looking at that important preliminary preamble position in the statute that says bicyclists riding the normal speed of traffic are not required to ride as practicable. The justice also got the definition of traffic wrong. He did not include bicyclists when looking at how the term traffic is read in the code. The code explicitly states that bicyclists are part of traffic. Another interesting error that occurred below that you reviewed de novo is the fact that the district court made a determination that the terms roadway and way do
Counsel,
not.
I see
Sure.
that the green light is on.
Bring it on.
This is a traffic infraction, correct?
Correct.
And as such, the standard of proof is preponderance of the evidence, right?
That is correct.
It is not a criminal case.
That is correct. So probable cause.
Don't we then infer that, as a matter of fact, that the judge made the findings necessary to sustain his finding that the offense was committed? In other words, he didn't have to make explicit findings as to what the speed was or what the condition was. Don't we assume or infer that he made those findings?
Well, Your Honor, two things. With respect to the legal errors, those are reviewed de novo by this court. With respect to the factual findings, you're correct that it is a very deferential standard, but the case law on point still makes it very clear that there has to be some evidence in the record, some competent evidence in the record, sufficient evidence in the record for any types of factual findings. Likewise, when the factual findings are based on mistaken interpretations.
Well, the evidence was the officer testified that he wanted to pass the bicyclists, that they were proceeding because he paced them out at 17 miles an hour, right?
That's correct.
Can't a judge just infer that that is below the speed, the normal speed of traffic, given that we don't have, other than a school zone, when flashing, we don't have speed limits that are less than 20 miles an hour, certainly.
Well, actually, Your Honor, I would differ with you on that. There are a number of provisions in the law that require bicyclists, and all traffic for that matter, to ride at a speed that is reasonable and prudent given the environment, including surface conditions, including traffic control signs, and including other traffic.
And the judge was shown a video of the area why can't the judge simply infer? And why can't we, because there was no request for more express findings, why don't we presume that the judge made those findings?
Well,
In other words,
because-
that it was at a speed less than the normal speed of traffic.
Right, because and this is where we go back to the judge's repeated misunderstanding and statement on the record of the statute with language that doesn't exist in the statute. So it looks to, it appears as if the result that the judge reached is based on its mistaken understanding of the law, which is something that you can review anew.
Well, what the judge said is that he didn't move as far right as possible, right? When someone wanted to pass.
And that in of itself is inconsistent with Edwards versus Town of York and other case law that say that practicable should not be read in the context of a safety statute as the same as possible. So there's
The video that was admitted showed that this stretch of road had 2 lanes and then a fog line, and then on the shoulder it was paved. And there were 2 cyclists riding abreast next to each other. One was on the shoulder, and your client, according to the testimony, was on the fog line or just to the left of the fog line. Is the legal issue here whether your client had to pull onto the paved shoulder when the police vehicle came up to him?
when the police vehicle came up, is that the legal issue? I think that the issue before the court is, one, whether the bicyclist is required to ride as far right anywhere, whether it's the shoulder or the roadway way, which I think are 2 discrete areas. And if they are, then do any of the exceptions apply? And so in this particular case, we're dealing, like I said, with a...
Counsel, apparently the booming that we're hearing is
Oh,
you.
I'm sorry.
So you can just stay a little further,
I am booming, I'm sorry. Let me see what I can do.
a little further back from the mic.
Okay, great. So let me make sure that I answer your question, Justice Horton. Would you re-ask it so that I make sure I get it, the answer you want?
I mean, do you agree that the law required Mr. Ray, assuming his bicycle was moving at a rate slower than vehicular traffic, to be on the fog line or as close to the fog line as possible?
Okay, so first, I think that Mr. Ray had to be operating less than the normal speed of all traffic, not just vehicular traffic. But secondly, the Maine Motor Vehicle and Traffic Code defines the term way, which is the key term, and roadway in the statute. And those 2 terms are areas that are areas where vehicular traffic travel, where they are moving along. And that, in the statute, in multiple places, not just in 2063-2, but also in 2063-5 and other places, says that we're dealing with the area that is essentially the travel lane where vehicular traffic travels. So the answer to the question
his
is
question is
far
does he-
right of the travel lane or the roadway or the way. I believe they're all used interchangeably within
So
the
that's
statute.
a yes. He had to be as close to the fog line as was practicable under the circumstances.
Right, and he also had the ability under 2063-2A, which is a separate section that was added to clarify that bicyclists can use the shoulder or the breakdown lane to travel, whereas motor vehicles and vehicular traffic may not do that.
Counsel, what if there were 3 bicyclists? What if there were 3 bicyclists riding side by side? What's the obligation of the 3rd bicyclist that's closest to the center line of the road?
Well, I think each bicyclist is going to have to abide by the law,
And
so
what does the law require?
so it depends on what the normal speed of traffic is for
Let's
the.
assume they're going slower than the normal speed of traffic.
Okay, so if they're going slower than the normal speed of traffic, then you would look at the additional exceptions and provisions within the statute. You would look at Has that bicyclist made a determination that it is unsafe to ride further
Let's say
right?
none of them apply. Let's say none of those other listed exceptions apply. Does that bicyclist have to just move as far over as he can without hitting the middle bicyclist?
Well, those exceptions include other bicyclists, right? So they do include when you're passing another cyclist, or if there's another cyclist that you believe is doing something
Your
dangerous.
fundamental point is that they don't have to go into the shoulder, that to go as far right as practicable means as far right towards the fog line. And whether it's probably single file, if there's a bunch of them, they just have to, they don't have to go into the shoulder. Is that correct?
That is correct, Your Honor.
But I think Justice Douglas's question is, let's say there's three abreast, and let's say the middle one is riding on the fog line, and one is in the shoulder, and number three is actually in the travel lane because they're riding abreast, and it's the center one is riding on the fog line. Does the one that is in the travel lane have to just squish as close to his compatriot as possible, or does he have to drop back to get also onto the fog line or further?
Right, and I think that like we said, if none of these exceptions apply,
Assuming that.
then that bicyclist has to take into consideration all of Maine law, what is safe, making sure that he gives reasonable notice for people to perceive, or she gives reasonable notice for others on the roadway that they're sharing the roadway with to perceive and react to their movement, because these other traffic
As
laws
running out of
apply.
time, I just want to get you right to the point.
Sure.
Yes
It's
or no?
it's certainly practicable that they can drop back to drive as close to the line. You seem to be reluctant to say that there actually is a prohibition against riding two abreast.
Yeah, there is no prohibition against riding two abreast. I'm not reluctant to say that.
Thank you, counsel.
Thank you.
Mr. Semon.
Thank you, Madam Chief Justice, and may it please the court. The plain language of the statute says that a person operating a bicycle slower than the normal speed of traffic must keep to the right portion of the way as far as practicable, unless certain safety exceptions apply. Because the language of the statute is unambiguous, we need to look no further to understand its meaning. The trial court found that, more likely than not, Mr. Ray violated the statute because he did not keep to the right portion of the way as far as practicable. That finding was based on competent evidence, namely the police officer's eyewitness testimony that Mr. Ray kept riding alongside his companion rather than move further to the right. Mr. Ray himself testified that his tire was probably on the left side of the fog line as well. Although Mr. Ray now argues that that police officer's testimony was not credible, a trial judge has the best opportunity to assess credibility, and we should not second-guess that assessment here on appeal. Because Mr. Ray did not request additional findings, we furthermore must assume that the trial court implicitly found that the statute's exceptions for bicycle safety did not apply. Those implicit findings must be upheld because they were also supported by competent evidence, that being the police officer's testimony and the video that was provided. Because the trial court's decision correctly applied the law and was supported by competent evidence, it should be affirmed. Nor should we second-guess the trial court's decision based on unpreserved arguments raised for the first time here on appeal. Mr. Ray never asserted at trial that he had determined it was unsafe to move further to the right, nor did the evidence at trial compel the court to reach that conclusion, since, after all, his cycling companion was able to operate further to the right. Also, Mr. Ray never asserted a violation of his discovery rights, or his rights under the First Amendment, or his rights under the Fourth Amendment at the trial court level. So those issues are also not preserved for appeal, and the evidence in the record does not prove any such violations. Therefore, this court should affirm the district court's decision, and I welcome your questions.
So,
Counsel?
Counselor, it's your position that there was a duty here to go into the shoulder, correct?
That's correct, Your Honor. The state believes,
Would there be a duty to go into the shoulder if it was unpaved? And if so, why or why not?
the state doesn't believe that there's a requirement to move into the shoulder if it's unpaved because
Where in the statute does it make that distinction?
we believe that in the statute it would be under 2063-2 when it is unsafe to do so. If it's unpaved and a cyclist is riding,
So only if the bicyclist said, I believe it's unsafe, and the court believes that he believes it's unsafe, but otherwise he has to go into an unpaved shoulder?
if the cyclist makes the determination at the trial court level and the court finds that believable, then yes, Your Honor.
And if the court doesn't find that believable, he says, I think it would be safe to go into an unpaved shoulder, do they have to go into an unpaved shoulder?
They have to move as far on the way to the right as is practicable.
Well, isn't that the issue here, though? I mean, you talked about the factual determinations, but there really was no dispute as between the officer who testified and Mr. Ray, that Mr. Ray was traveling at the fog line. I mean, his wheel may have been slightly to the left, matter of inches, whatever, but, I
That's
mean, the
correct.
officer didn't dispute that, did he?
No, he did not, Your Honor. That's
Okay.
correct.
So we know that he was far over in the travel lane, and doesn't that then lead us to whether the statute, which says shall operate on the right portion of the way as far as practicable, that then becomes a question of statutory interpretation, does it not, as to what the way is?
That's correct, Your Honor. An appellant is arguing that way, roadway, and lane are all used.
Well, appellant is arguing that way includes the entire width between the boundary lines in which vehicular traffic, in other words, the width used for vehicular traffic, which is the language of 10192, right?
That's correct, Your Honor.
And you don't disagree that vehicular traffic is not supposed to travel in the shoulder.
That's correct. However, there are instances where vehicular traffic does go into the shoulder.
Well, it
But
does.
bicycles aren't defined as vehicles.
That's correct.
So the entire width used for vehicular traffic between boundary lines, how can that include a shoulder, whether or not paved?
Your Honor, whether or not the fog line is used to determine the boundary lines, the state believes
It is
that
the painted line, isn't it?
that's correct, but the state believes that the definition of boundary lines is the entire width of the way, including the shoulder, and that fog lines are merely used as
But is the
safe-
shoulder used for vehicular traffic? To pass? I mean, is traffic supposed to pass along? I understand people can pull over into the shoulder.
It's used as a breakdown lane.
That's
It-
correct.
This doesn't say moving vehicles in
It's-
the lane. It
it's-
says used for vehicular traffic. And vehicles can move into the shoulder and for any number of reasons, can't they?
That's an astute point, Justice Douglas, and I agree with it.
It's called a fog
Always good
line
to
for
call
a
a judge
reason,
astute.
isn't it? Isn't it called a fog line so it's illuminated, so cars do not go into the shoulder mistakenly?
That's correct, Your Honor. However, I don't think that the fog line defines the boundaries of the way itself.
So where do you determine, where does your definition of the boundary line come from?
It comes from the end of the road. It's the entire
No.
width.
I'm saying in the statute, or in the motor vehicle statute, Title 29A, where are you finding the definition of the boundary line?
Your Honor, I find this distinction in, and maybe this is sidestepping your question, and I don't mean to do so.
Well, I'll come back if you do.
I trust you will, thank you. In Section 29A, Section 2051, lanes are defined, or I'm sorry, ways are defined in that they can incorporate more than one lane. And therefore, lane and roadway can be defined similarly in that they are used for vehicular travel. However, to conflate lane, roadway, and way
Well, there was
together,
at least two lanes on this road.
that's correct.
So we're not trying, I don't think that they're arguing that lane and roadway are the same.
I believe in an appellant's in the appellant's brief that they try to use lane and way interchangeably, and they say that in the statute that they are used interchangeably. And I think that that goes against the canons of statutory interpretation and statutory construction because the
So let me take you
legislature,
back. I'm trying to get to what's your definition of the boundary line for the way?
the boundary line for the way is where the paved road ends, Your Honor.
And again, where in the Title 29A do you find that definition of the boundary lines?
I don't have that off the top of my head right now, and I'd be willing to
So is a
readdress
reasonable
that.
alternative to that, looking at the fog lines as being the boundary lines of a way?
It's an alternative, however, I don't think it is the best answer.
Well,
Can
let's
we go to
assume,
what the judge actually found in this case? I mean, the judge, what happened in this case is the chief saw them riding side by side and moved up next to them. Apparently, he could have passed them, by the way, contrary to the findings, since he moved up adjacent to them, and said, single file, boys, single file. Or
Correct.
single- All right, you agree they don't actually have to ride in single file?
No, they don't have to ride single file, they have to move to
All
the
right.
right portion of the way as far as practical.
Well, and then but then, didn't the judge have the wrong standard when he said he found that they didn't move as far right as practicable because someone wanted to pass? I mean, the statute doesn't talk about somebody needing to pass.
No, that's correct, Your Honor. The trial court judge did not have the benefit of having a dictionary or...
Or
the-
citing the statute accurately.
If we conclude that the limitations of the way are in fact the fog lines, the white lines, the shoulder lines, did Mr. Ray violate the ordinance, the statute?
Yes, Your Honor, because he still had the ability to move further to the right, and that is getting into single file behind
he
either
was
in...
right on the fog line. If he doesn't have to get into the shoulder, how can he be more practicably go farther than the fog line when that's the end before the shoulder begins?
Mr. Ray had the ability to either slow down or speed up so as to allow the vehicle that was traveling behind him to pass him.
Apparently, the vehicle could have passed since he pulled up beside him, and that's not an element I'm going to suggest to you of the statute. But I think that Justice Meade's question was, if we find that the definition of way, in other words, that he must operate on the right portion of the way as far as practical, is defined by the fog line, if we assume that,
Yes.
did he violate the statute?
If it is defined by the fog line, then no, Mr. Ray was not in violation of the statute because his tires were to
You're
the
not
left of it.
agreeing that the fog line is the definition. Fog
Right.
line
But that is
doesn't
correct.
appear-
I'm not conceding
why
the
we're here
point
today.
And
that...
we understand you don't agree with that.
Fog
I just-
line does not appear in the statute.
Correct.
And does every paved road have a fog line?
No, it does not, Your Honor. That's an astute point as well,
If
Justice
the
Hoyle.
road does not have a fog line, does that mean that the entire lane, the way would be considered the entire paved portion of the road?
I believe it would.
Because there are no boundary lines,
Well,
other than the end of the asphalt.
correct, and that's what the state's position is.
What do we make of section 2A? Notwithstanding subsection 2, a person operating a bicycle may travel on paved shoulders. Does that have any impact at all on this case?
Your Honor, I believe that that's a clarifying statute whereby the purpose of the statute is road safety. And I believe that 2A is a clarifying statute that delineates the rights of bicycle riders so that they can operate on roadways safely.
Okay, so it doesn't affect the issues before us today?
No, Your Honor.
Is there anything in the statute that prohibits vehicles from traveling in the shoulder, on a paved shoulder, that you're aware of?
No, Your Honor. There's nothing in the statute that prohibits that.
Is this statute even applicable, given the circumstances? And if so, why?
The statute is applicable because the appellant in this case was traveling at a speed slower than the average pace of traffic and was
What's the
operating...
evidence of that?
Excuse me, Your Honor?
What's the evidence of that?
Is that the officer testified at trial that he had to slow down in order to accommodate the two cyclists, and that both parties agreed that the appellant, Mr. Ray, was traveling at approximately 17 miles an hour.
Well, let us assume, contrary to your point, that it was unambiguous language. If we find that this language is ambiguous, then what are the statutory construction tools that we should use to arrive at the result that you want us to?
Yes, Your Honor.
What in the legislative intent, otherwise using our other tools, suggests that bicyclists should have to go into shoulders, including unpaved shoulders, when somebody wants to pass them?
Your Honor, if the statute was ambiguous, which I'm not conceding that it is, then in order to discern its meaning, we would go into the legislative history. We would look at the committee minutes in which the statute was written in order to determine the legislative intent. However, that's not the case here, and we need to look no further than the plain meaning of the statute.
What
Right.
about subsection 5 that says a person riding a bicycle on a way has the rights and is subject to the duties applicable to the operator of a vehicle? I mean, doesn't that make clear that they have the right to operate in the travel lane?
Your Honor, they do have the right to operate in the travel lane. However, when they're operating below the normal speed of traffic, they have this statute unambiguously establishes a general rule that when a cyclist is traveling slower than what is the normal speed of traffic, they have an affirmative duty to move as far to the right as is practicable.
And given the
Far to the
findings
right of the way.
Of the way,
And that's
correct,
the
Your Honor,
issue,
thank
isn't
you.
it?
Given the findings of the court in this matter, how do we know that none of the exceptions contained within this statute were applicable to take
Well-
us out of this statute applying to?
Thank you, Justice Lawrence. Absent a motion for further factual findings pursuant to Rule 52 of Civil Procedure, the law court must assume that the district court found all facts necessary to support the trial court's findings, and therefore, the district court is not required to infer that the exceptions applied.
Do you agree that bicyclists have an equal right to the road as cars?
Yes, Your Honor, I do. But I believe that when they are traveling in lanes slower than the average, than the normal speed of traffic, then they do have the affirmative obligation to
And
move
we
to the
should
right.
treat,
Cars don't have to pull into the shoulder.
This is correct, and that is what this statute is aimed at. Is that it is a safety statute. This is made so that bicyclists and motorists can operate on ways safely and do so in a rather harmonious way.
So you don't want bicycles riding at 10 miles an hour in a 50-mile-an-hour zone with the cars in the middle of the lane.
That's right, Your Honor. Appellant argues that is a straw man's argument, that to
but
argue.
why do we want to encourage them to have to go into unpaved shoulders? Doesn't that kind of have a safety issue involved? Maybe it makes sense to send them over to the fog line as far as practicable, but why do we want to hurl them into unpaved shoulders?
That's a great question, Justice Connor. And
Also an astute question.
Is an unpaved portion part of the way?
an unpaved portion, that's a very astute point,
Even
Justice
better
Douglas. You guys are full of very great points today, and it looks like my time is done.
That's called Saved by the Bell? Okay.
Saved by the bell. Thank you all.
Thank you. And Ms. Boxer-Macomber, you reserve 3 minutes for rebuttal.
Sure, and I love your questions. I love the opportunity to entertain them.
Well,
It's
can
great
I
to-
ask the same question? If we find it ambiguous, what should we look at?
Well, if you do find it ambiguous, it would be inconsistent with the Semon decision, which says that 2063-2 is an unambiguous statute. But however, the legislative history here is fascinating, and it really is designed to protect vulnerable road users and to ensure not just the safety of those vulnerable road users, but everyone on the way. Going to some of the questions we heard about, like why would you have a separate subsection that says bicyclists may ride in a paved shoulder in addition to being able to ride in the way? It's precisely because we want to protect all users. We want to protect drivers from a bicyclist who is forced to ride in an unsafe place from weaving in and out. We want to give everyone notice to perceive and react to the actions of other people on the roadway. And if you force bicyclists to weave in and out, if there's things on the edge, on the shoulder,
This is a civil violation in the sense that it's not criminal, but is it a penal statute?
There's a fine involved, and so I
I guess then I'm sort of getting at, is there something like a rule of lenity? In other words, that because it is a punishment as opposed to a civil, that we should be interpreting it if there's ambiguity in favor of the defendant?
Yes, I would agree with that, Your Honor. And one thing that we did not touch on here is the exception C, 2063-2C, which talks about a bicyclist's right to not comply with the riding as far right as practicable statute if they're proceeding straight in an area where right turns are allowed. And we did have Mr.
Well,
Ray.
we have to assume that the trial judge made the findings necessary to support the inapplicability, don't we?
No.
Of those provisions. I mean, there was no request that he elucidate his findings any further.
Well, they still have to be based on some competent evidence in the record, and the only evidence in the record is that area was laden with areas where there were opportunities for right-hand turns, there were intersections, right and left driveways, right and left, and the like.
Do you agree that some public roads do not have fog lines?
Correct, Your Honor.
When a road does not have a fog line, does a cyclist have to pull to the edge of the pavement?
Well, then you would be looking.
If the cyclist is going less than the normal speed of traffic.
Right. Yes, of course. We're going to be looking at all of the language of the
Why would
statute.
the fog line in this case make a difference?
Well, because in Maine, we have all different types of shoulders. And so it's not a fog line. I mean, that is considered to be a shoulder. So there are some areas, I think what the legislature was trying to do was not force bicyclists into all the different types of shoulders and to allow bicyclists to choose what shoulders might be safe for them. Like if there's clear visibility and it looks like a great place to ride in the shoulder, the bicyclist gets to do that. If not, they have to ride as far right as practicable on the edge of the way.
Thank you, counsel.
Thank you.
And thank you to both attorneys. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. We don't tell you what our decision is here today. I am going to point out that for Mr. Semon, he is a law student, and I assume this was your first argument in front of the court, but we don't invite you back the way we do once you're admitted to the bar on your first argument, but that makes this particularly, given that we're appearing in front of students, particularly meaningful, I think. So thank you as well. And thanks to everybody here for having us. We love coming out to the schools. We do it every year, and we will continue to do it every year. Tomorrow we will be actually at Lewiston High School as well to hear cases, and looking forward to that. So thank you, and with that, we will be in recess on this matter.